My name is Ravi. I'm from Armchair Criminal, and I welcome you all to this part of the program. This is the fifth part of a six-part series on confessions. In this part of the program, we will primarily consider how the common law rule applies in admitting confessions. However, there are three types of answers a police or an individual could receive from a suspect: admissions, or where there's an admission and a denial, or thirdly, complete denial. So let's ask ourselves the question: can confessions be admissible under the common law? The answer is yes. Section 118 says any rule of law relating to admissibility of confessions or mixed statements in criminal proceedings, then goes on to say. So therefore you have the answer: confessions or mixed statements is admissible. We know that, having looked at section 82, the definition of a confession, which is adverse to the person who's making it, either in part or in total, completely, to a person in authority or otherwise. Therefore, it begs the question: what is a mixed statement? We will consider this, but what it means is where there is a confession admitting the guilt, basically, at the same time making an exculpatory remark. So both are there. Therefore, it becomes a mixed statement. Before we go to consider that, let's ask ourselves the question: where does the common law fits in with regard to the admissibility of confessions? Where the confession is primarily not regulated by the Police and Criminal Evidence Act, common law rules come into play. A classic example of this is when the case that we considered, Crown and Parks. This was a case that came to the Privy Council. You would recall, in that case, the defendant was accused of murder, having stabbed the victim, who told her mother who was the perpetrator of the crime, and the mother challenged the defendant, accusing him of stabbing her daughter, to the extent where she tried to restrain him until the arrival of the police. He didn't answer. In fact, he pulled a knife on her. At trial, you would recall that he didn't give evidence, but he made an unsworn statement. He was convicted, and that conviction was affirmed by the Court of Appeal. I think it was from Jamaica, by the Jamaican Court of Appeal, and eventually came to the Privy Council. The Privy Council upheld the Chief Justice's decision in that trial. The fact that the defendant did not give a reply was sufficient enough to accept that as an admission. In other words, the court can infer that his failure to answer is an admission. Now, it is important to understand why that was allowed. Now, Would you expect that to be a fair decision if the defendant had been at a police station and he was interrogated in the absence of a lawyer? Most people would say that it is unfair. Why? As opposed to, in this scenario, the mother's challenge to the defendant and receiving no answer. The logic behind is this: the deceased mother and the defendant were regarded as in equal power to each other. Namely, here you have a mother, a civilian, and the defendant. They were of equal rank. But when a police officer comes in, it raises the bar. So remember that where there is a disparity between the parties, it should be possible to argue that silence alone should not be inferred with guilt. However, we will expand this topic when I consider how to become a duty solicitor and defending suspects at police stations, when I deal with them as a different subject of their own. Next question that I would pose is, what is the view with regards to admitting comments made by a defendant out of court statements? I already touched upon it. Now, there's a difference between inculpatory remarks, in other words, where there are admissions, what could be said as confessions, and mixed statements, which contains admissions and a denial. It may sound a bit ridiculous to say both at the same time, but there are instances. For example, you could have a situation where there has been a violent incident. What are the three options? Yes, I beat the hell out of the man. Or I am the victim, that is at the other extreme. 3, I defended myself. By saying defended myself, what does it contain? 1, I was there. 2, I did take action to defend myself. So you have a scenario there. Therefore, that is what is the difference between inculpatory and exculpatory remarks. Traditionally, it has always been the case that where there are inculpatory remarks, you would admit them. Equally, there has been a fashion that exculpatory remarks, mixed statements, can be disregarded with the part that is supporting the defendant. But we will realize that the shift has taken place in favor of admitting the whole lot. Now, at this juncture, let's pose the question, why exculpatory remarks are excluded and how can they be admitted? Generally, exculpatory remarks are made out of court, so therefore they are hearsay evidence, and people would not admit to something unless they are guilty and that is the truth. Why would one do it? if a person is admitting to something against their interest, then one would have thought that there is ring of truth in it. Whereas exculpatory remarks, it is a human thing for most people to deny their wrongdoing. In other words, some people will go to great extent of concocting a story, fabricating, inventing a defense. Now, the next case that I would consider is the Crown and S. S was a youth, and he was one of, I think, 5 people or 6 people who were charged with a robbery. Save for him, everybody pleaded guilty. He went to trial. At the police station, he gave no comment in the interview. And at trial, the defense was, I was unaware of the robbery taking place in the bus where I was. I thought there was an incident taking place. I got off and got on to bus number 2. The same victims that was in the bus was there, and another incident took place. First incident, I was unaware of what was happening, that a robbery was taking place, and in the second one, I was not involved. That was his case. The prosecution cross-examined after his examination in chief, but there was no suggestion that his case is a recent invention. Whereas the prosecution case has always been that you were part and parcel of the other boys who did the robbery and pleaded guilty. Either soon after the examination in chief or during the cross-examination, the defense counsel was able to secure the notes from the police station interview attendance of the solicitor who was there. First brush of the reading of those papers, the instructions to the solicitor was consistent with what he has said in the interview. And there was discussions between the judge, the prosecution, and the defense counsel. What it transpired is that first the judge said the boy was badly advised. I'm not going to allow an adverse inference to be drawn. And when the matter was closely examined, it transpired actually his instructions are not quite consistent with what he has said. He has said, I didn't answer questions in the interview. The boys who did the robbery are my friends. I didn't want to implicate. So this is quite different to what he said earlier. Nothing to do with the boys. I was not involved, don't know who they are basically. So the judge ruled that document not to go in. He was convicted. He received a fairly lengthy custodial sentence for a young man who has never been in trouble. And he appealed. The Court of Appeal held that the learned judge was correct indeed, and that it didn't help the young boy to put his mixed statement in at all. And I have the authority here. And the defense counsel in that case wanted to adduce solicitor's notes under section 114 in the interest of justice. But the Court of Appeal said on paragraph 17, if these notes had been admitted, the jury would have learned that the appellant's account had changed fundamentally from when he gave his very first account. As we read those notes of interview, he told the solicitor in clear terms that he knew the first robbery was taking place at the time of it. So this is not what he said earlier. He knew that such a robbery had taken place when he ran off with his co-accused and then boarded the second bus, and he knew that the second robbery was also taking place. What a contrast. Far from assisting the appellant, therefore, in our view, this would have undermined further what was in any event somewhat unsatisfactory account of the appellant's presence at those two robberies. In any event, we read the transcript of Mr. Devlin's cross-examination, that's the prosecuting counsel. He did not put to the appellant that what he said was recent invention or fabrication. So the prosecution didn't say in cross-examination to this young man, you are fabricating or inventing evidence. In which case he might have had a way in to bring a previous statement to show consistency that it in order to rebut the allegation of recent fabrication. Then the Court of Appeal went on to say this. Accordingly, we are satisfied that the recorder, in all the circumstances, was perfectly entitled to exercise his discretion in the way that he did, and the failure to admit the notes of interviews does not in any way undermine the safety of the conviction. So that shows that just because it is a mere mixed statement, that there could be instances where the judges very correctly can exercise the discretion not to admit the evidence. The next question what I propose to ask myself is, what is the logic behind this rule? In other words, inculpatory remarks are admissible if there is a limit to the admissibility of mixed statements. What is the rule? Or where there is a statement which is completely exonerating the defendant, i.e. making a complete denial. The reason that inculpatory remarks are admissible is, as I said earlier, unless there's a truth, unless it is true, why would a normal person, I use the word normal here, in other words, is not mentally unwell or anything, would admit to something he or she is not responsible? People wouldn't generally do it. Of course, there could be circumstances where people are admitting to things that they haven't done, like to protect someone else, not mentally well, happy to accept anything that is thrown at them, or susceptible to suggestions, wanting to protect someone else, or being at an embarrassing situation, which we have, I think, looked at previously. But generally, that is, a person would not do that. Whereas people who deny and make mixed statements, could be that they are just trying to cover their tracks. So therefore, The courts traditionally have taken things on board with a pinch of salt from those who make such comments, because there's a presumption that people will refuse to accept responsibility very easily for their wrongdoing, because the consequences could be catastrophic depending on his or her personal circumstances and the allegation. Now, how does this rule the admissibility of mixed statements works in reality? The prosecution can adduce what the defendant has said in an interview as part of their case, or even significant statements at times. And equally, the courts will want to protect the interest of the defendant, because the court will be very keen to make sure that the defendant gets a fair trial. The authorities that I would consider is Crown and Pierce and Crown and Hamilton, but that is a case more on bad character and other matters, which I don't think we need to worry at this stage. But I will refer to the case of Pierce. What the court did say is this. This is a case that involved admissions, voluntary statements, and the way that it has been dealt with, or it is to be dealt with. Courts have always admitted declarations that is made by the defendant against his interest, which is clear that I have said and repeated it few times, because of the obvious reason of one would not admit to something unless that it is true. Statements where there are mixed statements, that is where the problems occur. In dealing with this, the court summarized the principles, referring to a case, Story and Anwar and Donaldson. The summary is this. I read: 1. Statement which contains an admission is always admissible as a declaration against interest and is evidence of the facts admitted. With this exception, a statement made by an accused person is never evidence of the facts in the statement. In other words, save and except for the admissions, everything else is not facts in the statement. 2. A, because there are 3 sub-paragraphs under the main paragraph 2. A statement that is not an admission is admissible to show the attitude of the accused at the time when he made it. This, however, is not to be limited to a statement made on the first encounter with the police. The reference in Story to the reaction of the accused when first taxed should not be read as circumscribing the limits of admissibility. The longer the time that has elapsed after the first encounter, less the weight which will be attached to the denial. The judge is able to direct the jury about the value of such statements. So, first principle is clear about the inculpatory remarks. Second one is admitted to show the attitude of the person, how he reacted. What are you saying? That kind of a thing. Because the demeanor, everything could be material. And the longer the delay to make that statement, less the weight is. The reason behind this, the longer the time that you have time to think. You have time to manufacture your case, tailor it to what you want to say. So the weight goes down. Whereas, person get accused, bang, no, I didn't do it. That is more powerful. B, a statement that is not in itself an admission is admissible if it is made in the same context as an admission, whether in the course of an interview or on the form of voluntary statement. It would be unfair to admit only the statement against interest whilst excluding part of the same interview or series of interviews. It is the duty of the prosecution to present the case fairly to the jury, to exclude answers which are favorable to the accused, while admitting those unfavorable would be misleading. That is what I talked about. The court would be very keen to see that justice is done. Interest of the defendant is maintained. Because otherwise what you are presenting to the jury is half the story. What are admissions you are putting before the jury? What he denies is not. So in order to give a balanced view, you present it to the jury in its entirety. Say, the prosecution may wish to draw attention to inconsistent denials. A denial does not become an admission because it is inconsistent with another denial. There must be many cases, however, where convictions have resulted from such inconsistencies between two denials. Now, we looked at the fairness to the defendant. In doing that, we also reminded ourselves that the prosecution has a duty to be fair when presenting the facts. If there is an inconsistency, what's wrong with the prosecution exploiting it? Just as the defendants and their counsel will exploit where there are inconsistencies in the prosecution case. However, where there is a contradiction between two denials, it doesn't necessarily mean that those denials does not become an admission because it is inconsistent with one another. There may be convictions which have resulted from such inconsistencies between two denials. For example, we looked at the case of S. We saw what the Court of Appeal said. There's a fundamental change in his defense from what he told the solicitor at the police station to his evidence. They both are denials. So in such contradictions, that is something to be looked at. Then the third part of the summary is this. Although in practice most statements are given in evidence, even when they are largely self-serving, there may be a rare occasion when an accused produces a carefully prepared written statement to the police with a view to it being made part of the prosecution evidence. The trial judge would plainly exclude such a statement as inadmissible. Just because a prepared statement is given at the police station, it doesn't necessarily mean, according to that reading, that the judge doesn't have the power to exclude. In my experience, I have not seen a situation where a learned judge would take such a drastic action, where the defendant gives a prepared statement at the police station through his solicitor. The reason being that at police stations, you are required to raise your defense. However, there are limitations in giving prepared statements at police stations. I will consider in quite detail this particular issue of attending police stations and defending suspects at police stations when I consider the subject of defending people at police stations and techniques of participating in interviews. That is a completely different subject which needs to be addressed separately. Now, coming back to this was a case where the defendant was investigated for handling stolen goods, and he was interviewed. He made certain admissions, and then again he was interviewed. I think it was 3 different occasions that 3 or 4 occasions that he was interviewed, giving big statements during the course of it. And there, the court did come to the conclusion that it was a case where the judge did not have the reason to exclude these big statements, because the Court of Appeal felt that the statements made fell within principles 2A and 2B, which I just referred to. With regard to Hamilton, in my view, this is not something that would add much to this part of the session, but it is a case that I would consider when we look at duty solicitors' work at police stations and with regard to possibly character evidence. What I pose to ask myself next, how about the statements which are called mixed statements? How about those statements which are called mixed statements, namely which has a defense, in other words material to exonerate the person, and at the same time admitting to parts of the offense? By considering the case of Pierce, you would have noticed that where the court is moving towards, the trajectory is clear, that you put the whole statement in. Now, the case of Sharp, this was a case of burglary. The police attended the scene. They saw the defendant get into a car and drive off at speed. Once they found him again, they lost the defendant because he was driving very fast. And a few days later, he attended the police station and participated in the investigation, where he said that yes, I was around the vicinity. I heard the burglar alarm going. I was jogging, or I was basically looking for my part of the car which has fallen off because of a minor accident, but I was not involved in the burglary. And he did not give evidence at trial. He was convicted and he appealed. His appeal was allowed and the conviction was quashed by the Court of Appeal, and the Crown appealed to the House of Lords. And dealing with the appeal in the Court of Appeal, what is important to note is that the House of Lords said in dismissing his appeal that the jury should be given direction in a way that they could understand and follow, that they could not fairly evaluate the facts in an admission unless they could evaluate the facts in the in the excuse or explanation accompanying it, and that they should be directed that the whole of the mixed statement was to be taken into consideration as evidence in deciding where the truth lay. The judges summing up were appropriate on the respective weight of the admissions and the excuse or explanation, and on the defendant's election not to give evidence. Therefore, you would know the old-fashioned thinking that one would exclude anything and everything which is exculpatory is now eroded. What the courts will do is leave everything for the jury to decide what weight that they would attach, taking into account the whole of the evidence, which, if I may humbly say, that is a far better and a reasonable thing to do. Then the case of Aziz, again this is a case which is more relevant to dealing with bad character and the application of those principles. As you might know, that after this topic, what I propose to consider as the main subject, I have the authority here. That is what I've been looking at, whether to completely consider this here or not. I will consider that, very likely to be considering that in the subject of bad character. That leads me to look at the case of Pepworth and Doyle. Pepworth and Doyle, the facts were quite simple. It's basically a corruption case where an employee of a large company was placing printing orders left, right and center with a company owned by Doyle. There was ample evidence to suggest that they had more than a working relationship. And the allegation was that Pepworth is placing orders with Doyle is because Pepworth was getting basically a backhander, a bribe. And they were both convicted, and they appealed on the ground that, I have the authority here, they appealed against their conviction on the grounds inter alia that the judge had erred in giving the jury that direction that they should be given mixed statement directions where the statement contained inculpatory and exculpatory material. And the judge's direction to the jury was when directing the jury as to the police interviews, gave a direction that the contents of the interview did not amount to evidence of the facts stated. That was with regard to the exculpatory remarks. The matter went to the Court of Appeal, and the Court of Appeal dismissed the appeal. And the court said that fairness to the appellants, who had all the times denied any dishonesty and not accepted any ingredients of the offence charged, did not require the judge's mixed statement direction. And the court said that the convictions were not unsafe. In coming to this conclusion, what the court said also that the question could only be answered by reference to what happened at the trial and could therefore only be finally resolved at the close of the evidence. Moreover, judges, when applying the test to interviews or statement, should bear in mind that the rule that exculpatory parts of mixed statements were evidence of facts contained therein was based on consideration of fairness to the defendant and simplicity for the jury. To the extent to which at the close of the evidence the prosecution placed significant reliance on incriminating parts of an interview, the more likely it was that jury should be told that parts which explained or excused those incriminating parts were also evidence in the case. But although an admission in interview of an ingredient of the offence would often constitute a significant admission for the purposes of applicable test, it would not necessarily do so. So you would see that the courts nowadays is moving away from giving mixed statement directions. But it doesn't necessarily mean that even in those circumstances that where there is evidence, strong evidence, like in this particular case, the transactions and everything, that the person cannot be convicted and that person's conviction still be regarded as safe. That is all I propose to say at this stage of this session. The final part will deal with co-defendants, evidence against another defendant, and other few parts that in order to conclude the 6-part series. I hope that you have found it useful and interesting. I look forward to seeing you again. Thank you for your valuable time, and God bless.